Hey everyone, Andrew Schultz, Principal Broker with Own Buffalo Inc. here, and I wanted to come to you today with some breaking news with regards to the New York State eviction moratorium. As you can see on the screen here, New York State has begun opening courts up to hear eviction cases for both non-payment as well as for holdovers, lease violations, things of that nature. However, there are still many restrictions in place. I want to spend a couple of minutes walking through what this new administrative order means for you as a residential landlord here in the state of New York, and then we're actually going to deep dive into the order itself a little bit so that you can see the text itself. So this is Administrative Order number 231, issued on October 9th, 2020, going into effect October 12th, 2020. So we're actually about 2 weeks since this has been passed, but we were waiting on for some clarification before we decided to post a video on it. And here's basically what we've found out thus far. You can now file for eviction proceedings for non-payment and holdover in the state of New York, subject to several criteria. First is going to be the scheduling of the courts. Second is going to be the New York State Tenant Safe Harbor Act. And third is going to be the federal CDC order, which limits evictions as well. So those are the three main subject tos right now. And you might be saying to yourself, well, if I can't evict tenants who are protected by Safe Harbor Act, and if I can't evict tenants who are protected by CDC order, what good is this? Well, it does a lot for you in that it allows you to at least start the process, and it forces the tenant to bring their case. So if you have a tenant that's protected by Tenant Safe Harbor Act or the CDC order, chances are you're not going to get that eviction awarded to you. But the tenants are going to be required to come in and answer that court case and present their case to show that they are truly COVID impacted. And that's really the beginning of the process here. As far as other things that we're going to be subject to, scheduling is going to be a bigger issue than it has been in the past. This is going to take a long time. There's going to be a flood of new cases, and there's already old cases that were left unresolved that still need to be heard before any of the new cases can be looked at even. So you're going to have some time frame here before you're able to get in and actually get in front of a judge. No one really knows how long, and it's going to vary court by court. I suspect that a lot of these will start being heard remotely until the situation changes and it's a little bit easier for people to get together in courtrooms. But it's going to take a period of time in order for you to get even on the docket to have your case heard. I would consider mediation. I would consider trying to get some kind of a stipulation signed and recorded by the court if you go the mediation route. And what that'll do is it'll basically give you the benefit of the court hearing without having to go through the court hearing, if my understanding of this is correct. Essentially what'll happen is if you come to an agreement with the tenant and you hash everything out, they're going to make payments of whatever for the next however many weeks until they're caught up. And if they fail to make a payment, then the warrant can be issued to have them evicted. If that's the recorded stipulation and the tenant misses the payment, now you have some legs to move. So mediation might be a good idea. If you go the mediation route, get a stipulation and get it recorded. And definitely consider a cash for keys as an option. It's one of those things that maybe the tenant hasn't been so inclined to be interested in a cash for keys because they knew they couldn't be forced to be evicted or anything like that. Once we have a situation where a tenant might be in a position where they have to move due to an eviction, they may be a little bit more forthcoming with a desire to work with a cash for keys scenario. So that's something to keep in mind. Another issue here is going to be judicial discretion. It's very real and it's going to happen. Especially, I think you'll see this in the smaller courts where judges may not be quite as up to speed with what the rules and regulations are, what the current laws and procedures are with regards to evictions. You may find that in some courts, judicial discretion becomes an issue. If that becomes an issue, you're going to have to chase it higher up the food chain. Unfortunately, there's not a lot that can be done there. But if you find yourself in a situation where you think that your case was not handled properly based on the current laws, I would definitely recommend chasing that, because what we're going to have is judges and attorneys trying to force issues incorrectly, which could lead to bigger issues and things down the line. And there's also going to be some changes to the types of notices and the timeframes of notices that have to be delivered to tenants as part of these proceedings as well. So that's something that you're going to want to speak to your attorney with to determine what the proper notices are that you have to deliver based on your scenario, because there's all kinds of different criteria that would impact this, such as if you have a mortgage, who backs your mortgage, whether or not you have subsidized tenants, things of that nature. This is one of those situations where you definitely are going to want to speak to an attorney. My strong recommendation on this is do not attempt to do one of these evictions yourself. You're going to burn more time. You're going to burn more money. Hire a professional to do it. Hire an attorney. If you need an attorney recommendation, I can recommend attorneys in the Buffalo and in the Rochester markets. Outside of that, I don't know as though I have necessarily good referral sources, maybe as far as Syracuse. I'm not entirely certain on that. But if you are looking for an attorney, you can feel free to reach out to me, and I'll definitely do my best to help you with that however I can. So all that being said, we're going to jump into the actual order now, and you can start to see what I was talking about. We're going to scroll right through this. If you want to go and actually pull a copy of this yourself, just go to Google and search for Administrative Order 231, and it'll pop right up. So this just goes through, I went through and highlighted some of the key sections here. Effective October 12th, 2020, all residential eviction matters, non-payment and holdover without regard to the date of commencement may resume statewide with certain important caveats. And then it goes in and talks about the time limits and things like that. We'll scroll down through here a little bit further. This is something I'm not sure I mentioned, pre-March 17th residential matters. So if you had an eviction case that was scheduled or heard pre-March 17th, or if there was a warrant of eviction issued but not executed prior to March 17th, that tenant does get the right to have a conference with the court to make sure that they are not a COVID-impacted tenant and would be subject to either one of the Tenant Safe Harbor Act or the CDC order. They do get that right to have the conference before the eviction is granted or before the warrant is executed and they are removed from the property. They do talk about alternative dispute resolution, mediation, things of that nature, remedies, prohibitions of evictions. So this is what I was talking about. These next two sections talk about the Tenant Safe Harbor Act as well as the CDC order. And actually, it's interesting because when you get into the nitty-gritty of the law, you wind up with interpretations and things like that that differ between just simple things. Like differences in language can cause great differences in the way that something is interpreted and followed. And this actually, the administrative order highlights a couple of issues where there are language mismatches that could create issues in courts that will need to be heard and resolved, essentially. So that kind of covers that. We'll scroll down a little bit further here. Commencement papers and residential eviction proceedings must continue to include a notice indicating that respondent tenants may be eligible for an extension of time to respond to the complaint. We'll show you that attachment in a second. And again, you're going to have to include this as part of your notices. Talk to your attorney so that you don't screw something like this up. Attachment A is the actual executive order, the actual administrative order. It's only a one-pager, and it's signed by the Chief Administrative Judge of the courts, Judge Marks. You can go through and read that. Basically, this is the actual administrative order, and then prior to that was the letter issued by Judge Marks, and that was kind of the breakout of what the executive order, how to interpret it, things of that nature. So Exhibit 1A, these are the new notices that you're going to have to include along with your other notices, and it sounds like you need to include both the English language copy as well as I think this is Spanish language copy. And this is for New York City, as well as for outside of New York City, two different websites that people can contact. And again, in English and in Spanish, pretty straightforward. And then attachment B goes into all of the various executive orders and things of that nature, and covers basically all of if you're looking and you see an item that's referenced in the administrative order, chances are it'll be attached to that PDF there. So that's what you would be looking at from that perspective. That pretty much wraps things up for me here. I wanted to get this information out to as many housing providers as I could so that people understand, at least here in the state of New York, for non-payment, for non-COVID impacted tenants, you might be able to get that eviction. You could definitely proceed with holdover evictions. You could definitely proceed with lease violation evictions, things of that nature. Non-payment is still a little bit sticky, especially if they're a COVID-protected tenant, but you at least have the option to get the ball rolling and get the tenant in the court to present their case and let the court start making some decisions in those matters. So It's a little bit of a step forward. It's not, we're not throwing the doors of the courts open and moving forward or anything like that. This is happening, slowly across the state. I spoke to an attorney last week who works out in the Rochester market, and they had indicated that Rochester and Monroe County actually have their own separate housing court part that they're using to hear housing court cases right now. And last I had heard end of last week, Niagara Falls and the town of Lockport were starting to hear cases. The city of Lockport and city of Buffalo had not yet started hearing cases. However, I did get an email earlier this week indicating that Buffalo is going to start moving forward on cases, and that will probably mean that more of the smaller courts in the region start moving forward on cases as well. Once they see how Buffalo is operating, they'll kind of take that lead and move from there. If you have questions on this, please feel free to reach out. You can find our social media, obviously, in a variety of places. Don't forget about the Ask a Property Manager show every Wednesday at 10 a.m. Eastern. We also offer that show as a replay on our Facebook page and on our YouTube page, as well as tons of breaking news and things like that over on our YouTube page. We try to post the breaking news stuff over there first and then cross-post it to Facebook after. If you're having questions or you're not sure how to proceed on something like this, you can grab a free 30-minute consultation with me over at ownbuffalo.com. That's a great opportunity to ask questions in a private setting where you have the ability to just ask and get some answers. Doesn't necessarily mean that I'm going to be able to answer every question, and I'm certainly not an attorney. I'll probably wind up referring you to an attorney if the question's outside of my scope, but at least this gives you a little bit of information to operate off of moving forward. Thank you all so much for watching. We really do appreciate it. This video shall not in any way be deemed to constitute legal, financial, or tax advice. Please speak to your attorney before you take the advice of anybody that you watch on the internet. That's generally a good way of looking at life. Thank you all so much for watching, and we'll see you next time.